Courthouse case, People versus Joshua Wara.
Cover me vote for the people.
Mr. LeBeau's case. Wara.
Joshua Wara. Thank you, Your Honor. Mr. Wara, can you state your name, sir?
My name is Joshua William Wara. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No.
Okay. All right. Well, I would say there come some perils with you representing yourself. You understand that, sir?
No. I know
You
the
don't
mission
understand?
I'm a jailhouse lawyer.
Pardon?
I know what I'm doing. You are working.
I'm sorry?
You are being paid by Adolph Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati?
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited
Thank
to
you,
do so.
Cedric Simpson.
What do you want to do with your case today?
Ellen Wara, Adolph Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay, but I've got to do something. I've got to do something. I've got to do something with your case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue. And what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for
If
10
you-
times
if
the amount of what was stolen from me. They stole $666.8 million from me. They then turned it into $5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion.
I'm not claiming to be a lawyer or a mathematician, but I do know two plain facts. Sovereign citizen legal theories don't hold up, and basic arithmetic still works that if you take $5.6 trillion and multiply it by 10, the result is $56 trillion, not 500.
And I can
Okay.
criminally prosecute to the
No, I'm with you.
extent, which is
I'm
my
with you.
right.
I did the math too. Listen, here's the thing.
Mhm.
I have to advise you, because if you are going to represent yourself, what you're here on, okay?
I'm doing it over Zoom. 'cause they're
So
trying
you're
to kill
here
me.
on a complaint that alleges that on October 15, 2025 on South Main Street
The Pentagon's
in the
using
city of
prisms
Ann
to
Arbor,
make,
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
Which is actually 10 times the amount, because I can sue because it's conspiracy to murder, and sovereign law would make it 100 times the amount. But since it is conspiracy to murder, sovereign law
I'm with
does
you.
not
I got
exist.
you. I just have to let you know what you're
Which
charged
means
with.
I can sue for
There's
1,000
also a
times the
count
amount.
2 on the complaint that alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay. So there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Cedric Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel.
No, I do
all
not
you
want
have to
any
do is
counsel, and I
just
want a bench
listen-
trial,
listen
not a
to what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
backed
any
on
point you do,
objective evidence.
if
A
at
bench
any
trial
point
is
you
objective
do
evidence.
want counsel, you just have to let the court know, and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay, so What do you want me to do with your case today?
I would
Now
like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence
trial?
and a jury
Well,
trial
that's
can
not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the
you
jury.
can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law and it's conspiracy to murder, and Donald Trump and Elon Musk are involved, and I can sue for 1,000 times the amount. And sovereignty
Your Honor,
does
if I
not
can
exist
if I
because the
can
amount of money that
I
they
don't know,
put
I've
that
not been
out
very
on
good at
me,
it, but
and Donald Trump and Elon
oh,
Musk and Adolf
so-
Mack and Doug Minkoff and Jeffrey Peake and Ellen Wara all have estates that and residencies in states that do apply the death.
A lot of people might assume this man is dealing with a serious mental health issue, but no. This kind of behavior is unfortunately very common among extreme sovereign citizen believers. Making outrageous threats is practically routine in that movement. For example, there was a woman named Lindsay Daysky, someone well known in that community, who once attempted to file a federal lawsuit against me and several others, including her ex-partner and Judge Triplett. In that filing, she even claimed she would push for the death penalty against all of us simply because the court found her unfit as a parent.
Gotcha. Let me hear from somebody else real quick.
Your Honor, if I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has
I'd like
one.
to give
So
Donald
we would
Trump
need
the
more
right to
time.
care.
The defendant's on parole, and if he's entertaining the idea of representing himself, I think it's important that we refer him to first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm gonna do. Sir,
Frederick Simpson.
I'm gonna adjourn your
I do
case
not want a
out.
jury trial. You cannot adjourn this. This is a high profile case. Where I can't. Yeah.
Okay, but you
There
haven't
are too
seen
many
the
people involved.
You
You have a
haven't
Neuralink
seen.
in your brain and you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Alrighty then. So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
and based on
listen.
factual evidence, the jury trial can be bribed.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please. With all evidence, I would like to.
You want to represent
phone records
yourself?
and all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Warren.
examination?
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peake, Adolf Mack, Donald
We're not
Trump,
bringing out those people
Elon
back.
Musk.
Yeah, okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, would we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So I'm going to indicate he doesn't want his discovery. Says he doesn't need it.
If you were physically present when the incident happened, then discovery isn't even necessary in order to respond. You can build your defense directly from...
Here's what I'm going to do. I'm going to set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir, I'm going to
Yes.
give you your preliminary examination. So your preliminary
you.
examination will be set in person on...
Your Honor, I'm so used to
And,
just saying, yes, sir.
Adolf
No, I
Hitler
know,
is in
but
the
I
judicial
realize it's
court
close. But
with Carol
it-
Conkey and East Hope, et cetera, et cetera.
excuse me?
Carol Conkey is involved. She is at 22nd Judicial Circuit Court with Feiger and Ellen Wara and Jeffrey Peake. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's today?
That's a yes or no.
Yes, sir.
Thank you.
What is today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolph Mack. I'm giving him the electric chair. And I'm suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolph Mack, the electric chair.
Okay,
if
thank
Elon
you.
Musk works with me.
Okay, so here's what I'm going to do.
And Donald Trump.
I don't know that we'll be able to go given how you're
Yes,
acting.
we will.
but
I want
I'm
a
going to
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolph Mack, JP Morgan.
I'm going to set your preliminary examination for October 28th, 2025, 9 a.m. That will be before me. You know, I'm not, if I let the PD off, because I may on my own motion be referring for competency, I will do it that day. But so right now, to answer your question, Mr. LeBeau, you are still on the case. Because I think the more the merrier.
Thank you, Your Honor.
You're welcome. No, you're not really thanking me, but I get it. All right, thank you. Thank you, sir.
Looks like we finally stepped off the midnight train out of Crazy Town, and now we're headed straight to Colorado, where yet another sovereign citizen is confidently wrong about everything, and the judge wastes no time putting him in his place.
5T 5884. Entries from the people.
Ken G for the people, Your Honor.
And with that, good morning, or rather good afternoon now for the defense. State your first and last name for the record.
Robert Richards.
And with that, go ahead and have a seat. We're going to go ahead and do housekeeping. So we're here for motions, and there's no resolution in this case?
No, Your Honor.
All right. And so with that, did you receive Mr. Richards' motion to dismiss the charges in this matter?
Yes, Your Honor.
And Mr. Richards, would you like to supplement the record by any oral arguments?
No, ma'am.
All right. And so for the people?
Your Honor, we would respectfully ask the court to deny this motion to dismiss. There is a factual basis for the charges, as well as an unwillingness to unwillingness by Mr. Richards to come to a resolution in this case. So I believe that going to trial is appropriate resolution.
And so I just want to make sure I clearly heard you. You asked me to deny the motion because he's unwilling to resolve the matter?
We have not come to a resolution in this case.
Do you think that's a legal basis in which the court could do that?
And additionally, I believe there are enough facts to support the charges, Your Honor. And I believe that the people can prove this case with a reasonable certainty at trial.
And so as to Mr. Richards' motion, did you actually pull the cases he has cited?
I apologize, Your Honor.
As to Mr. Richards' motion, did you ever pull the cases that he has cited?
Yes, Your Honor. And the people would argue that these cases are not pertinent to these charges.
Can you tell me why?
Under Flournoy v. First National Bank, Mr. Richards quoted, "If the state converts a right into a privilege, the citizen can ignore the license and..."
And this would be under which case?
He quotes Flournoy v. First National Bank of Shreveport. It's 197, California.
And before you go any further, because I did pull these cases, one of them, the Cites incorrect. All right, you may continue as to Flournoy versus First National Bank of Shreveport.
He quotes that case saying, "If the state converts a right into a privilege, the citizen can ignore the license and fee and engage in the right with immunity." I apologize, Your Honor. I believe that's Shuttlesworth v. City of Birmingham, 373 U.S. at 268.
Okay, because that's the case that I could not find.
I also could not find that case, Your Honor.
But you were able to locate it?
I was not able to locate that case, Your Honor.
I'm sorry?
I was not able to locate that case, Your Honor.
Okay, that's the incorrect site. And so as to the others,
When you choose to represent yourself, the court may give you a little bit of flexibility, but at the very least, you need to get your legal citations correct. Shuttlesworth versus Birmingham is a real Supreme Court case and an important part of the civil rights movement, but it has absolutely nothing to do with someone acting like a grown toddler claiming it's a constitutional violation to be required to have a driver's license to operate a car.
As to Murdoch v. Pennsylvania, 319 U.S. 105, no state shall convert a liberty into a license. So I believe that case was decided in 1943 about wares and merchandise. I don't believe that pertains to a driver's license, and as the facts in this case do, Your Honor.
so with that, Mr. Richards, would you like to respond to her arguments to the court as to why I should not grant your motion to dismiss based on the cases you have cited?
Well, we can start with Article 6, Clause 2.
Of which constitution?
The United States Constitution.
Let me go ahead.
All persons born and naturalized in the United States are subject to jurisdiction are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of liberty or property without due process of law, nor deny any person within its jurisdiction equal protections under the law. Now I'd like to cite the definition of liberty: the freedom and exemption from extraneous control, the power of the will and its moral freedom to follow the dictates of its unrestricted choice and to direct the external acts of the individual without restraint, coercion, or control from others. I apologize. The first amendment I read was Amendment 14, Section 1. Article 6, Clause 2, all debts, contracts, and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. The Constitution, the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or the laws of any state contrary to the contrary withstanding. The senators and representatives before mentioned and the members of the several states legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. The United States Code is the supreme law of the land. All states are required and bound by it. And the USC recognizes no law for a driver's license, for inspection, for insurance, or for registration. And the only law that they do have on the books is regarding registration for commercial vehicles. The word driver is a commercial term, which means that you're using the road for a commercial purpose or for a hire purpose. I have stated since I met with the officer who initially pulled me over that I am a private traveler.
All right. Any additional arguments you'd like to make to the court?
I mean, I can cite the right to travel, which is Second American Jurisprudence, Constitutional Law, Section 329, page 1135, which states personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon by horse-drawn carriage, wagon, or automobile is not merely a privilege which may be permitted or prohibited at will, but a common right which he has under the right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee, one may therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected not only in person but in safe conduct. And personal liberty consists of the power of local motion to change situations or removing one's person to whatever place one's inclination may direct without imprisonment or restraint unless by due process of law.
Lately, I've seen a new citation being passed around online supposedly from a major 2021 Supreme Court case involving a so-called sovereign citizen out of South Carolina named John Dallin, who was pushing this right to travel nonsense. Here's the reality. What people are quoting Second American Jurisprudence Constitutional Law Section 329, page 1135 isn't a Supreme Court ruling. It isn't precedent. It's not even case law. It was just a filing submitted by the defendant himself. That document was simply a request to let him proceed in forma pauperis, meaning he wanted to move forward with his case without paying the required filing fees. The Supreme Court denied that request, and because he never paid the fees, his so-called historic case was dismissed on the spot. So, to put it plainly, that citation isn't just wrong.
Any additional record before the court rules?
I can read the USC that regards the requirement for registration, since we have a registration here, but I don't feel like that's really necessary at this point, do you?
Well, that'll be up to you. I'm giving you your time before the court.
49 USC 31704, vehicle registration. After September 30th, 1996, a state that is not participating in the International Registration Plan may not establish, maintain, or enforce a commercial motor vehicle registration law, regulation, or agreement that limits the operation in the United States of commercial motor vehicle. This is not registered under the state law if the vehicle is registered under state law participating in the plan. And that's USC 4931, subsection 31704.
All right. And thank you for that. And with that, the court will now rule as follows in this case. As to Mr. Richards' motion to dismiss, he has cited as his legal authority Murdoch versus Pennsylvania, which can be found at 319 U.S. 105. It's a United States Supreme Court case from 1943. And then we have Flournoy versus National Bank of Shreveport, which can be found at 3 Southern 2nd 244. That is a Supreme Court of Louisiana case from 1941. Both are still good case law. The court did try to find this Shuttlesworth versus City of Birmingham. The site is 373. I also looked at 375 US 260. That case does not exist under that site. Okay. And as to each of these cases, we are here on this driving under restraint and an expired license plate charges. The first is a Class A traffic infraction. The second is a Class B traffic infraction, ineligible for a jury trial, but a court trial. And as to Flournoy versus the First National Bank of Shreveport, the actual issue in that case is that they did challenge, and that would be Flournoy challenged a statute that was limiting in value bank shares for taxation. The court found that that was unconstitutional. It has no bearing on a driving under restraint or a license plate being expired. And then in Murdoch versus Commonwealth of Pennsylvania, what was happening there is that the city of Jeannette, and it was an ordinance by the city of Jeannette in Pennsylvania, was prohibiting the sale of goods, wares, and merchandise of any kind within the city by canvassing for soliciting without a license. And the United States Supreme Court found that that was in violation of the Constitution, the United States Constitution, freedom of speech that is guaranteed by that First Amendment, because it was preventing people that had religious beliefs or were on the streets just preaching the gospel from distributing religious literature and then having personal visitations with individuals as they walk by. And they found that that requirement prohibiting any sale of goods, ware, or merchandise of any kind without a license was in violation of the First Amendment. And so as to all that has been cited by Mr. Richards, I appreciate it, but we do have laws here in the state of Colorado that do require you to have a driver's license and that privilege, and also have your vehicle license. And so as your motion to dismiss the charges in this case, that will be done.
I'm still waiting for the day a sovereign citizen actually wins a case based solely on their sovereign citizen logic, but until that fantasy becomes reality, which it won't, I'll just keep sitting back and enjoy.
So at this point, Mr. Richards, we're going to go ahead and go to what is called housekeeping. So have you gotten down to the district attorney's office and received your discovery in this case? All right, you will need to have your discovery because the people are indicated they have 2 audio files and 3 video files for a total of 5 media files that they may be using in a trial. You will need to be able to review those because I'm going to set some deadlines because I need the parties to confer about what will be coming in and what will not be coming in. And it'll be extremely beneficial if you know exactly what that is. And so during housekeeping, what I do is I go back to the date and time that a case was filed with the court. And I review all motions or notices that could potentially affect trial in this matter. And since the not guilty plea was entered and the JASP order went into effect, the people filed 1 notice of endorsement of witnesses on just September 12th of this year. Did you receive a copy of that? And could you approach? Here's all I'm gonna give you a hand delivered to your copy. These are all the people that they possibly or potentially could call, and that's for you. You can keep that. That's yours.
Wow.
Oh, that's who they're gonna call or potentially call. That's their potential witness list.
So the officers that were there on scene?
Yes,
There
whoever.
were 3 officers, not 4.
And they're saying there's 4. So,
I saw 3.
and so that's who they're intending. They could potentially, I'll make it tell you that they will actually call those 4 officers or whoever the 4 witnesses are listed because I didn't look at it that closely. But that's who they're intending or potentially could use as witnesses in this case. If you want to know how those individuals are related to this case, that's where the discovery comes in because there should be reports from those individuals or some type of statements or some type of mention of those individuals in somebody else's reports. That discovery will tell you exactly who those people are, hopefully. And also we have all these audio and video files. So with that, would you like to go down and get your discovery? In this case, it's free.
Yeah.
All right. So could you give them your address to your office? And you need to just go to, I think the fastest way is to go down there. Is it the fastest way to go down there and get it? Or does he do it online or?
To request it online first, and we have to process it for him to be able.
So what happens if he goes down to your office? Can you request it as he's standing in your lobby?
I believe Central Services needs some, I believe they said it's 7 business days at least to process discovery.
I know, but that's for the processing time, but the actual request. Can a person go to your office and request a discovery in person?
I'm not sure with that method. I think it's usually online, but online should be fairly easy too.
And I'm going to assume there may be a mechanism because not everybody has access to a computer.
Yes, Your Honor.
So would you, if you'd like to, go down to the office and see what they have to say about how you can request that. Give them your address. You'll have to go directly to their district attorney's office.
Going to ignore my right to liberty and my right to local.
At no point does the Constitution grant anyone a special right to drive a car just because they call it locomotion. What the courts are denying isn't freedom, it's the delusion that you can operate a motor vehicle on public roads without a valid driver's license.
No, I'm just telling you down to Colorado law that these are valid charges that the state of Colorado has the authority to actually enact these types of statutes. Okay. And so with that, for the people, did you file any additional motions or notices that the court is not aware of?
No, Your Honor.
And there were none other than the motion to dismiss filed by you, Mr. Richards. Is that correct?
Yep.
Okay. So again, the people have 2 audio files and 3 video files for a total of 5 media files. And with that, the court will now issue the following orders. As to those 5 media files, the parties are to conclude their conferral as to which portions or which portions will or will not be used of those 5 media files by this next deadline. Also, if there's any additional witness endorsements or initial witness endorsements, they must be filed by this deadline. And if any party wishes to use an expert, that expert must be disclosed by that same deadline, along with the CV for the expert. And Mr. Richards, you know what a CV is, correct?
No.
Okay, a CV is the equivalent of a resume for an expert. It actually stands for curriculum vitae, CB, curriculum vitae. And all it is basically a resume for the expert to say why they're expert, what type of training, experience, classes they've attended, those that they've actually taught at themselves, recognitions within that industry. And also pursuant to Rule 16, I'm going to order that a summary of the expert be provided. In other words, tell the opposing party what the expert will be testifying to. So again, the parties are to confer as to these 5 media files of what will and will not be used by this deadline, conclude that conferral. Also, any additional or initial witness endorsements, if you're going to include anyone as an expert, you must designate at that point in time in writing that the person is going to be an expert. Tender over to the opposing party the CV for that expert, and also a summary under Rule 16 of what that expert will be testifying to. That must be done by Friday, October 3rd. That if there are any objections to any redactions to that media or lack thereof, that objection must be in writing and it must be supported by a legal basis.
So if I just want to pay the fines now, you're obviously not going to side with me in this. So if I just want to pay the fines and walk away from it.
Not either siding with or for against anyone. I just follow the laws here in the state of Colorado.
My right to liberty is invalid. So if I just want to pay the fines and walk away from this, what?
No, you have rights and you have liberties, but also here in the state of Colorado, these are valid charges.
Not in the state of Colorado. I'm a man standing on land. I am not a dead entity inside of a state.
Okay. Would you like to enter into a plea agreement then with the people?
What are we looking at for fines?
Oh, I can do. Can we pass, Your Honor, while
You
we
may.
discuss it?
So the judge gives them a moment to step aside and discuss possible fines and penalties, which honestly cracks me up because the second his bogus citations were exposed, he instantly bailed on the Sovereign Act and waved the white flag. All that confidence disappeared real quick, but in the end they couldn't agree on anything, so the judge simply pushed the case to next month and set a new court date.
So this October 3rd, do I need to worry about that in this particular instance?
You still would,
I would.
if you would like to see
So I
what
need
the
to-
discovery is and if you want to object to anything.
All right.
So there's some additional deadlines. And so we are back on the record on Robert Richards, case number 25T5884. He is present before the court, and so is Ms. G for the people. And so if there are any objections to any redactions or lack thereof of those media files, in other words, people are going to use something that you don't think they should be able to use, or they're not going to use something that you believe they should be used, you must state that in writing, and you must support it by a legal basis. In other words, you just can't say I object. I have to know why you're objecting under the law. And you must tender over to the court the media in question by that next Friday, which would be October 10th. Now, failure to, even though you may have submitted a written objection that's supported by a legal basis, if I do not also receive the media in question by that next Friday, October 10th, then the court will deem the objection to be abandoned. And the reason why is this: I don't have access to their discovery. And so I don't have the media files. I have to be able to have the media file to review it, to be able to rule on it. Now, within that same written objection, the opposing party, you may respond to that objection with your own legal basis. But if you fail to respond, the court could deem your refusal or failure to respond as a confession of that objection. And I could grant that objection as written. But irrespective of if there is a response or not, if a written objection is filed supported by a legal basis and the objecting party has tendered over to the court the media in question by that Friday, October 10th, I will issue a written ruling on the weekend of October 18th. And so with that, because there were no testimonial motions, all motions and notices have been addressed. JASP order is still in effect. The parties, if they so choose, you may plead out at any point in time. And so with that, anything further for the people before I order Mr. Richards back here for the trial?
Nothing further, Your Honor.
And Mr. Richards, anything further for you before I order you back? And so I do order you to pay back here, and we will see you back here on October 22nd. That will be a Wednesday, and that'll be at 8:15 a.m. Again, Wednesday, October 22nd at 8:15 a.m.
All right, everyone. That's going to wrap up today's video. He was scheduled to appear in court this past Wednesday, but they never actually got to his case, so we're still waiting on new developments.